Supreme Court of Canada, case study number 3, Hall v. Hebert. This case was decided in 1993. Hall is considered the doctrine of ex turpi causa non oritur actio. This Latin phrase roughly means that plaintiffs cannot recover damages from their illegal action. It is also a leading case on contributory negligence. The facts in Hall were: plaintiff, Hall, was a passenger in the defendant's, Herbert's, car. Both were drunk and the car stalled. The driver got out and pushed the car to get it started again, while the plaintiff took the wheel to keep the car aimed at the road. He lost control of the car and it wound up upside down in a ditch, and the plaintiff was hurt. He sued the defendant in negligence. Hall was an appeal from the BC Court of Appeal. In the BC Supreme Court, it was found that the original driver, Hebert, owed a duty of care to Hall when he took control of the car. Liability was apportioned 75% to Hebert and 25% to Hall. The BC Court of Appeal reversed the trial judge's decision on appeal, holding that the doctrine of ex turpi causa did not permit Hall to recover damages resulting from drunk driving. The main issues in Hall dealt with the doctrine of preventing profit in negligence that resulted from criminal activity and also involved the nature of Hall's conduct. Does a person having the care and control of a car owe a duty of care to a clearly drunk passenger to prevent them from driving? And also, whether the ex turpi causa doctrine provides a defendant with a complete defense to the action. The appellant's arguments were: 1, Hebert, as the owner and driver of the vehicle, owed a duty of care to his drunk passenger to prevent him from gaining control of the steering wheel. 2, the ex turpi causa doctrine does not prevent recovery in this case, as the plaintiff was not seeking to illegally profit from his actions. In summary, the respondent's arguments were: the defendant did not owe a duty of care to the plaintiff. The doctrine of ex turpi causa prevented the plaintiff from recovering damages resulting from his illegal activity. The drunk driving. The court allowed the appeal, holding that the plaintiff was owed a duty of care by the defendant. It also outlined a very limited rationale for application of the ex turpi causa doctrine in Canada.
Courts should be allowed to bar recovery in tort on the ground of the plaintiff's immoral or illegal conduct only in very limited circumstances. The basis of this power lies in duty of the courts to preserve the integrity of the legal system, and is exercisable only where this concern is an issue. This concern is an issue where a damage award in a civil suit would, in effect, allow a person to profit from illegal or wrongful conduct, or would permit an evasion or rebate of a penalty prescribed by the criminal law.
Hall's legacy was to severely limit the application of the ex turpi causa doctrine in Canada. It will rarely, if ever, now be applied to deny damages for personal injury. However, the Supreme Court of Canada did not eliminate the doctrine, and in 2008, the Supreme Court of Canada revisited the doctrine in the case of British Columbia versus Zastowny. The decision of Zastowny reaffirmed the limited application of the doctrine, and the court compensated for the plaintiff's personal injuries. However, it denied the plaintiff compensation for lost wages for time spent in prison. This was in line with the reasoning of the Hall decision, which stated that the ex turpi doctrine operated in a very limited sense to protect the integrity of Canada's judicial system and prevent profiting from criminal activity.